How to resolve landlord disputes. Landlords and tenants don't always see eye to eye. In fact, many different types of disputes can arise. For example, you might request that your landlord make repairs, or you want extra time to pay your rent. Alternately, your landlord might not let you sublease your apartment, or they may discriminate against you illegally. Whatever the dispute, you should first try to resolve it informally through negotiation. If that fails, you can consider attending mediation or going to court. Method 1: Negotiating a resolution. 1. Document the problem. Whatever issue you are having should be fully documented. The documentation will be useful in case you can't negotiate a resolution and need to sue. Consider the following. If you have a problem with the unit, take pictures or video of the problem. You can photograph mold, leaky pipes, mice infestation, etc. Write down information. For example, if you don't have enough heat, write down the date and the temperature inside. If you are having trouble paying your rent, then document your expenses and your income. You'll want this information to show your landlord. 2. Talk to your landlord. Many disputes can be solved between landlords and tenants. Many landlords are willing to work out a solution to the problem you are having. Call up your landlord or stop by. Document what each of you said and the date of the conversation. Remember to be as friendly as possible. There's no reason to assume your landlord won't agree to help you out. 3. Follow up with a letter. If your landlord won't solve the issue, you need to follow up in writing. Send either a letter or an email. Mail letters certified mail, return receipt requested. The purpose is to document in writing that you have spoken to your landlord. Include the following information. The issue. For example, you can write, per out telephone conversation January 22, 2017, I am reporting that my radiator has not been working properly. How the issue has affected you. For example, as you can imagine, this has been most distressful. I have expected my apartment to be habitable in the winter. Instead, I am cold all day and night. The duration of the problem. I first noticed the heat went out on January 21, 2017, so it has not been working for nearly 2 weeks. Any steps you have taken to correct the problem? I bought an electric space heater to heat my apartment as much as possible. The heater cost $39.99. I'll also have to pay for the added electricity. What do you want the landlord to do? For example, please fix the radiator as soon as possible. 4. Wait for a response. Hopefully, your landlord will respond promptly. If not, you should wait a decent amount of time. The amount of time you wait should depend on the seriousness of the issue. You shouldn't wait more than a day for serious issues like a lack of running water, heat, or any other unsafe condition. 5. Negotiate. To resolve the dispute, you may need to give something up to get something in return. For example, if you want extra time to pay rent, you should be prepared to pay a penalty or a little extra in interest. However, you don't need to negotiate if your lease or the law requires your landlord to do something. For example, you don't need to pay extra to have your apartment properly heated. That's the law. 6. Call the local building inspector. If your landlord ignores you, you may need to call your Department of Health or your local building inspector. Look in the phone book for the number. They can send someone out to investigate if your apartment is not habitable. Only call if there is something wrong with your apartment that makes it unlivable. For example, insufficient heat or running water, or dangerous conditions, warrant a call to the building inspector. Don't call because your landlord won't lower your rent or refuses to let you paint the walls. These disputes have nothing to do with the health or safety of the unit. Try to get a copy of the inspector's report. This will be helpful in case you go to court. The city may fine your landlord for not fixing dangerous conditions in your apartment. Hopefully, that will spur your landlord to fix the problem. 7. Write down any resolution. If you reach an agreement with your landlord, get the agreement in writing. You'll want proof that you both agreed to a resolution. For example, if your landlord allows you to sublease your apartment, then you'll want that in writing. If you can't get your landlord to sign something, at least have them email you that they agree. 8. Take additional action, if necessary. If your landlord continues to ignore you, then you may be forced to take action. Each state has different rules for what you can do. You may need to consult with a landlord, tenant lawyer or legal aid clinic to fully understand your options. For example, you may be able to do the following. Repair and deduct. In some states, you can pay to have a problem fixed and then deduct the amount of repairs from your next month's rent. You probably have to send your landlord a letter explaining that you intend to repair and deduct. Withhold rent. In some states, you can refuse to pay rent until the problem is fixed. You should tell your landlord why you are withholding rent. You may have to pay the rent to the local court. Move out of the apartment. Depending on how serious the problem is, you might be able to break your lease if the apartment is uninhabitable. For example, no heat in winter makes an apartment uninhabitable. Method 2: Mediating a dispute. 1. Propose mediation. In mediation, a third party listens to you and your landlord explain the dispute. This person doesn't act as a judge. Instead, they try to help you both reach a resolution you can live with. Mediation is voluntary, so you can walk away at any time. Mediation can help you preserve your relationship with your landlord. This is critical if you intend to keep renting from them. You will typically split the cost of a mediator. Depending on the dispute, they typically charge a couple $100 an hour, which is probably cheaper than going to court. 2. Find a mediator. You can ask another tenant if they can recommend a mediator. If not, then look for a mediator in the following places. Telephone book. Look in the yellow pages under mediation or dispute resolution. Local community centers. Some communities have dispute resolution centers. Your city government's office. They might have a landlord-tenant mediation program, which is often free to use. Alternately, the office could point you in the right direction to find a mediator. Courthouse. Some courthouses have mediation programs or lists of mediators you can call. Stop in and check. 3. Participate in mediation in good faith. You should only participate in mediation if you are willing to compromise. You aren't likely to get everything you want in mediation. Participate only if you are committed to finding common ground. Mediation typically begins with each side laying out how they see the dispute. Be honest. Mediation won't work unless you say what you want. Watch your language. Although you want to be honest, you shouldn't be offensive. You might think your landlord is a slumlord, but you should be open to what they say. Try repeating what your landlord says to you. For example, you can say, "I definitely hear what you're saying. You are worried I've been late with the rent for the past 3 months." By acknowledging someone else's worries, you can calm them down. Maintain your cool. Sometimes people vent in mediation. Try to stay calm by taking deep breaths. 4. Caucus with the mediator. As mediation progresses, the mediator might decide to caucus with each person. This consists of meeting alone with you in your own room. The mediator shuttles between the rooms, telling you what the other side is thinking. Caucusing can be effective if you reach an impasse or if you are close to a resolution but can't reach agreement on the final few details. 5. Write an agreement. You should document any agreement you reach with your landlord. For example, if you agree to a new lease, then you should write it out. Your mediator can help you write an agreement. Both you and your landlord should sign. Keep a copy for your records. Method 3: Resolving a dispute in court. 1. Identify the law your landlord broke. You can't sue for every dispute. For example, if you want to paint your walls red, you can't sue since you don't have a right to paint your walls. You can only sue if the law allows you. Identify what law your landlord broke. Your lease. Your landlord must abide by the terms of the lease. For example, if the lease says you can sublease your unit, the landlord cannot deny you the right to sublease. Your local law. Most city and county governments set health and safety standards. If your landlord hasn't complied, you can sue. State law. You can find a summary of your state's tenant rights by visiting the Housing and Urban Development website here, https://portal.hud.gov, HUD portal, HUD, SRC equals, topics, rental_assistance, tenant rights. Click on your state. Federal law. Most anti-discrimination law is federal. You can sue if discriminated against on the basis of religion, gender, race, color, familial status, or handicap. 2. Obtain legal help. You will benefit from a lawyer's assistance. You can hire the lawyer to represent you, or you can only meet for a consultation where a lawyer will answer your questions. Money might be tight, but you can look for low-cost legal help. Contact your state or local bar association. Ask for a referral to a lawyer. Find legal aid if you are low income. Legal aid provides free or reduced fee legal services to people with low incomes. Visit. 3. Find the correct court. You can sue in different courts, depending on the substance of your dispute with the landlord. For example, consider the following. Housing court. Some cities have special courts for landlord-tenant disputes. These courts are set up so you don't need a lawyer, though you can have one if it is helpful. Small claims court. If you are suing for a small dollar amount, you can typically sue in small claims. These courts are designed for people without lawyers, and procedures are simplified. However, you might not be able to get everything you want from a small claims court. For example, you typically can sue only for money. You can't sue to force your landlord to do something. Regular civil court. You can bring lawsuits in the regular civil court for the county where you live. In most states, each county has a court. Check your phone book. You can sue for money or for an injunction, which is a court order to do something, or to stop doing something. Federal court. If you're suing for a violation of federal anti-discrimination laws, then you should sue in federal court. You can find the correct federal court by using the federal court locator here. 4. Draft a complaint. You begin a lawsuit by filing a complaint with the court. In this document, you describe the dispute with your landlord. You also explain the legal violation and what compensation you want from the judge. Your court may have a printed, fill in the blank complaint form. Often, housing courts and small claims courts have these forms posted on their websites. If not, you can stop into the court clerk's office to check. Not every court will have these forms, so you may need to consult with a lawyer or hire the lawyer to represent you. The lawyer can draft the complaint. 5. File the complaint. Make a copy of the complaint for your records. Also make several other copies. You'll need to send your landlord a copy and possibly provide the court with a few extras as well. Take all copies and the original to the court clerk. Ask to file. You'll probably have to pay a filing fee. Ask the court clerk for a fee waiver form if you can't afford it. Remember to serve a copy of the complaint on your landlord. Ask the court clerk for acceptable methods. Generally, you can have an adult who is not a party to the lawsuit hand deliver a copy. You might also be able to mail it using first-class mail. 6. Read your landlord's response. Your landlord has a right to respond to your complaint. They can provide their own background information on the dispute. They can also raise defenses. You will receive a copy of the response. Alternately, your landlord might simply show up on your hearing date and give an oral response. Often, your landlord will argue they didn't break the lease or the law. This is why you need evidence. Sometimes they might claim you created the problem. For example, if you have mold, then they may blame you for not ventilating the apartment. 7. Prepare for court. Gather your supporting documentation, letters, emails, photos, safety inspection reports. Put them in order. If you hired a lawyer, talk about what will happen in court. Sometimes, you might have a full-blown trial. This is generally true of discrimination lawsuits. In other situations, you might only have a hearing. If you need to testify, you should prepare with your attorney. They can ask you sample questions to get you comfortable with the process. 8. Attend your court hearing. Show up at court with enough time to find parking and go through any security. Try not to be nervous. Remember the following tips so that you can have a successful hearing. Dress professionally. People are judging you based on how you appear. Wear clean, neat clothes. Remember that conservative, dark colors are best. Testify confidently. Sit up straight and testify in a loud, clear voice. Answer questions affirmatively, without saying, I think, or I'm guessing. In fact, you should never guess. If you don't know the answer to something, say I don't know. Act respectful to everyone. Call the judge, Your Honor. Never interrupt your landlord when they are speaking. Discuss with a lawyer your next steps if you win or lose. You might be able to bring an appeal if you lose. Should you win, you'll need to talk about collecting on your court judgment. Tips. You might also want to consider arbitration, which is like a trial, except you present your case to an arbitrator instead of a judge. Arbitration often has some advantages. For example, it can be faster. However, many housing courts or small claims courts are also streamlined to resolve disputes quickly.